Well, I'm not going to show my face on the screen. I think you guys know what I look like. I hope. Um, and I want to make sure that if you're watching this on your phone or laptop or whatever, you're able to read the actual Google Slides presentation. So that's why I took my face off of there. And if you guys have not watched part one, this says part one. That actually should be part two. You know what? I'm going to go ahead and change it because I can. But this is part two of part one. And there will be a part three, and that will be next week. I will release that schedule on Monday, and I'll let you guys know when I'm going to be streaming next week. And that'll be the last lecture for the judicial branch, as far as I know, unless things change. I can go a little bit deeper into some court cases. I love Supreme Court cases. They're my favorite thing to teach because their stories are so rich and they're just so fascinating. And you guys will understand what I'm saying a little bit today, and then more so next week when we get into the juicy stuff. In particular, a lot of crime and how our civil liberties have been defended over the years or lack thereof. And it's pretty interesting to see the judicial branch change over time as well. That's what I think is fascinating. Um, and how civil rights has been defined by the judicial branch or lack thereof. We'll get into that with Plessy versus Ferguson. So yeah, be looking forward to that. I will also release a an assignment schedule for you guys next week as well. It's going to be a shorter week because we will be on Easter break starting on next Friday, and then you guys will be off until the following Monday. Just stay in the loop with things. Keep up to date with things. Check your emails every single day. Check your Google Classroom every single day. And I'm going to be reminding you guys of this every single time I live stream or if we do a Google Meets, which I will do a Google Meets next week as well. And I'll release that schedule. I will be putting that on calendar, and I'll put it on each class so that maybe we can have more participants. And it's okay if you can't make it. That's okay. I understand, but it's just to troubleshoot a few issues here and there with our class and with this whole online distance learning thing that we are all learning together. Teachers, students, parents, administrators, school board, you name it. The entire state is struggling with this. The entire nation is struggling with this. Just be patient and understand that this is a process and there will be some more information coming out. I'm sure of it. I have not heard, nothing's been confirmed, but just be aware that things could change one way or the other. I will get started here shortly. I hope you guys have been doing okay. I think this time has been good for some, and others have been struggling. Myself, I am really an introvert, so this time has not been that difficult per se, but I do miss my students very much so. I miss every single one of you guys. And human contact, human interaction is key to health, I believe, and just keeping sanity and all that stuff. Um, and I just want to make you guys aware that I do miss you, and I hope you guys are being safe and staying well during this time. Reach out to me if you need anything, big or small, and I can see what I can do to find some resources for you. And yeah, so we'll get started here shortly. But yeah, now as far as the judicial branch is concerned, will there be a test? I don't know yet. I'm not gonna say yes or no. If there is a test, it could be more traditional, more multiple choice, and it would be open source, open note, open book, whatever you want to call it, because I would not be able to control it unless school is not canceled or whatever. So yeah, another question I have about grades and assignments and learning opportunities. Um, am I going to put this stuff in the grade book? As of right now, no. And I'm not going to touch the grade book. The only time I will touch the grade book is if you have a missing assignment and you can still make that up. So if it was before break, and you know it was missing, you can just email me, and I will look at it and I'll update your grades. I've been doing that all week, really, this week and last week. I've been doing that, so be aware of that. That policy is still in place, and everything is just up in the air right now with grades and either if it's going to be pass fail or whatever. So just stay in the loop. The school district will communicate with you, I promise. Okay, I'm going to go and get started. I know it's 2 minutes shy of our start time. And I want to get through this. Like I said, I'm going to lecture through this. This is basically the start of the judicial branch. This is the start. This is how the judicial branch expanded its power. You will understand what I'm saying here in a minute. If you go back and look at and watch part 1, we discussed the structure, the purpose, the responsibilities, also the different court levels, the district, the appeals, and then the Supreme Court, and their responsibilities when it comes to judicial acts and making sure that either acts of our government are constitutional, or if laws are constitutional, with judicial review. So I highly recommend that you go watch that. It's pretty decent, I think, all things considering. And today we're going to look at how the Supreme Court it started, okay? And it's a unique history. It's kind of a brain scratcher to understand why it started like this and how. And you'll see here in a minute. So I'm going to go ahead and get started. So with the history of the Supreme Court, I always start with Article 3 of the Constitution. Now, we have studied Article 3 of the Constitution in this class, and I made you guys read through the Constitution and break down all 3 articles in particular. And Article 3 is very, very short in comparison to Article 1, which establishes the legislative branch, and then it's even shorter compared to Article 2, which establishes the executive branch. And really, Article 3 is going to establish the Supreme Court, and it's going to define how U.S. federal judges are chosen. Of course, we talked about how they're nominated by the president and then confirmed by the Senate, checks and balances. And there are no age requirements. There are no real requirements to be a Supreme Court justice. None. Zilch defined in the Constitution, which is kind of odd to me because the president is defined and then senators and House of Representative members are defined as well. But you're not just going to have some common person off the street being nominated to be a Supreme Court justice. You're looking for someone who has experience in the legal field. They were a former judge or attorney, or they've been in the judicial system for years and years and years. You want someone who is experienced. You're not just going to pull a teacher in there like me. But technically, I could be a Supreme Court justice, okay, according to the Constitution. But I would never, ever want to do that. That would be a very difficult job, very hard job. And this work is very, very difficult, guys. I want to express that. This is not an easy process. And we'll get into that here in just a moment in the next slide. Also, Article 3 is going to define the jurisdiction of the Supreme Court and the lower courts. And your right of a trial by jury is also redefined here now. That's ultimately in the Bill of Rights. We talked about that with the anti-feds versus federalists. But you are guaranteed a trial by jury in criminal court cases. Also, the definition of treason is found in Article 3, and that has been used a few times in our nation's history, and some very, very famous cases. Of course, the Rosenbergs. They come to my mind immediately after World War II when they stole the plans for the atomic bombs and sent them to Russia. And then Russia ultimately made their own bomb. And this whole definition was used in their court cases. So Article 3 is very, very short, but it does not list the responsibilities or the powers of the judicial branch, which is strange, which is odd, because the framers of the Constitution, they were very specific with giving powers or not giving powers to the president or to Congress. So to me, it's like, this is very strange. I've heard stories that the framers of the Constitution wanted to just get the whole thing done and then deal with the judicial branch a little bit later, or they didn't view the judicial branch as important as the other two branches of government. But regardless, it's just strange to me. But again, that goes back to the Constitution, to our very government being a living, breathing thing, a living, breathing document. And we'll see here what is going to define the judicial branch. Now, some vocab that's very, very important going forward here before we actually get into our first three court cases. You're going to have 2 points of view. And when we are studying these court cases, a judge is either going to have restraint or activism. Restraint or activism. And it's a pretty clear-cut understanding of how the judges interpret the Constitution. And remember, the main responsibility of the judicial branch is judicial review. And now judicial review in and of itself can be defined with restraint or activism. So restraint, you are looking at the Constitution and how it was originally written. Okay, so this is very, very strict. This is this is what the framers wanted, kind of thing. You also look at the intent of the law and why the law was written the way it was. So you cannot bend a particular law to fit a particular need in our country. You also look at precedents. So, meaning you respect what previous Supreme Court justices, Supreme Courts have ruled in the past, or even lower courts in the past. It's not just the Supreme Court. Um, and there's also an argument that the Constitution, under the restraint model, should only be changed through the amendment process. This is very difficult, and you're going to see that this idea of restraint is not going to be as popular today with our Supreme Court as it has been throughout history. Okay, this whole thought here, some Supreme Court justices would have this idea, but a lot are going to say, wait a second, the judicial branch can make changes to our Constitution when necessary. And we'll get to that, especially when we look at how your civil liberties have been defined and changed over time for the good. And we'll talk about, Miranda, Map v. Ohio. We'll even talk about the blunders. We'll talk about Korematsu versus United States, and then Shank versus United States. And we'll look at all the ways that our government, how your rights, how your liberties have been changed and defined, even as a student over time. Now, activism, that's the flip side. This is when you kind of look beyond what the framers initially intended. So this would be like, what is the Constitution saying we can do today? What is the Constitution saying we can do in 2020? And this viewpoint is more popular in today's current Supreme Court era, I guess, the modern era, not just now. But it's really difficult to push a document that was written in 1789 to fit the changing times, the changing needs of our country. And this is that whole living Constitution. This is when the Constitution can change over time, and the Constitution can adapt to fit the needs of our country. We have talked about that with the necessary and proper clause in Congress, and how things have changed and needed to change over time. Think about the internet. In 1789, they had no idea that there was going to be a World Wide Web, and Congress can write laws to address the internet. So that's part of that living Constitution. This is active, and it's necessary. It has to be necessary and appropriate. Like I said, it has to change and fit with the times, and can be involved in interpreting and enlarging laws. So this meaning the government can become larger and actually expand its power through this judicial activism. Now, if we were in school, you guys would have to tear apart several court cases, and you would have to examine what Supreme Court justices are saying, and whether or not they're using restraint or activism. And you would have to apply to see which which point of view these justices are leaning. And it's kind of interesting to see the difference. And you wouldn't believe it, but Republicans, Democrats, some are one way or the other. It's not Republican, Democrat. It just depends on the judge and the justice. Okay, so keep that in mind too. It's not just political. It just comes down to the judge. So, our first court case, and we're going to watch a video that I would show in class, all right, to summarize this. And here is the thing with court cases. All right, when you are studying court cases, before I explain Marbury versus Madison. When you are studying court cases, it is important to understand the history and the facts and what happened with the court case. But what is more important is understanding the impact. What impact did the court cases have? Now, you could study all day long about these court cases, but when it comes down to it, for you as a student, you need to understand the impacts and how it changed our nation and how it changed our government and how it changed the relationship between the federal government and the state governments. So when we are going through this, yes, we will get a little bit of history, but primarily what I am concerned about are the impacts. So Marbury versus Madison. This is the court case that pretty much defined and established the concept of judicial review. Okay, this court case, if you do not understand this court case, there will be an issue. All right, so judicial review is defined here with Marbury versus Madison. We'll watch a short little summary here in a minute. This is the first time that the courts are going to define any law or act of government unconstitutional. Remember, Article 3 did not give any specific powers to the judicial branch. This court case will define that power and the power of the Supreme Court. This is like the start. This is when the Supreme Court, quote unquote, gets their teeth. It's like when the teeth grow in a baby. So this is when the Supreme Court is going to start to wield and use its power. And this is also going to show, or not show, but define judicial review as a tool for checks and balances. Now, we talked last time, checks and balances with judicial review. It's like the final stop. It's the final check. And yes, things can be reversed. Court cases can be reversed. We will see that. We'll see that pattern. But it is really, really difficult to do so. And usually this is the final say in our government with the Supreme Court. And we'll see, things like Dred Scott case, Plessy versus Ferguson. Those things can be overruled, overturned. Okay, so don't think that they cannot be overturned or overruled. So keep that in mind. So there is a balance to this. This isn't just the final say, but normally it is. Okay, so let's watch a little bit of history, and then I'll go back to those other two court cases. Today's lecture is going to be a little shorter. Yeah, there's an ad.
Mr. Beat presents Supreme Court Briefs.
So this is a video that I would show in class. And Marbury versus Madison, this is going to explain some history to you guys. And I really like Mr. Mr. Beat, not Brief. Wow. And he's going to explain just some history behind this particular court case and why it is so important to our government. So let's watch it.
The District of Columbia, March 2nd, 1801. President John Adams just has a couple of days left in office, but he's been pretty busy making last-minute appointments for his Federalist friends to important positions. It's basically a mad rush to get them in before the new president, his arch-enemy Thomas Jefferson, takes over. He nominates 23 justices of the peace, basically judges in lower courts, in Washington County. One of those nominated was a dude named William Marbury. Like Adams, Marbury Marbury was a Federalist who talked a lot of trash about Jefferson when he ran against Adams before the election of 1800. Even though Adams nominated Marbury and the other 22 folks, and even though the Senate approved their nomination on March 3rd, and even though later that day Adams signed the commissions, which were basically the final orders so they could get to work, several of them didn't get the job. Wait, what? Why? Well, John Marshall, the acting Secretary of State for President Adams, did not deliver those commissions on time. Hey, speaking of Little John, my friend Jack Rackham,
Well, hello.
made a video about him over on his channel. Be sure to check out his video when you're done watching this one. Okay, back to the story. At noon the next day, March 4th, Thomas Jefferson officially took over as president. He instructed his Secretary of State, James Madison, to only deliver those commissions to some of the nominees. You know, the ones he liked. One of the people who never got his commission was William Marbury. Yeah, Jefferson didn't like him. Marbury was like, "That's messed up, man. I was promised that job." He wanted to force Madison to deliver that commission, so he petitioned the Supreme Court to hear the case, and the court actually said, "Sure, let's do this." They heard arguments on February 11th, 1803. Oh, guess what? By this time, John Marshall was Chief Justice of the Supreme Court. Wait a second, isn't that a conflict of interest? Shouldn't Marshall recuse himself from making a decision for the Nah. 4 of the 6 justices on the court discussed 3 big questions for this case. Number 1, should Marbury and the other justice of the peace nominees get the jobs they were promised? Number 2, can they even sue in court to get their jobs? Number 3, hold up, does the Supreme Court even have the authority to say they could have their jobs? The court announced their decision on February 24th, 1803. All 4 sided with Marbury. They thought Marbury deserved that position and thought, yeah, he should be able to sue to get it. However, hold up, Madison kind of won too, because the law that enabled Marbury to sue to begin with, the Judiciary Act of 1789, was actually unconstitutional because it gave the Supreme Court more power than the Constitution allowed. Wait, so the Supreme Court decided to weaken their own power?
Huh?
Well, not exactly. You see, John Marshall knew what he was doing. He pretty much did this. He had the long term in mind, baby. While the court gave up power by declaring the Judiciary Act unconstitutional, they also gave the court a far greater power. The power of judicial review, meaning they could call out laws if they went against the Constitution. So if the court could declare the Judiciary Act unconstitutional, they could declare any law Congress passed unconstitutional. You see, Lil John and the rest of the court had made the Supreme Court kind of a big deal. Dare I say, this was the most important Supreme Court case in American history. I'll see you for the next Supreme Court case, jury. First of all, if you were wondering...
Okay, so that's Marbury versus Madison. And just some history there for you guys. And again, I cannot express it enough. Judicial review, judicial review, judicial review. Now, we're going to take a look at 2 other court cases. And you can also lump these 3 court cases together. And you can also say that they expanded the concept of federalism. And this is going to expand, grow the federal government. If you go back to first semester, we talked about this whole conflict with the Articles of Confederation and how there was a distrust of a strong central government and the states kind of wanted to be their own thing. And over time, the U.S. federal government is going to grow and expand. And the Supreme Court is going to have a big part in this that you guys are going to see. Now, the next 2 court cases I'm going to share with you guys, I'm not going to go as in depth with as I do with Marbury versus Madison. And I believe I did assign an Ed Puzzle video for McCulloch v. Maryland, but I did not for Gibbons v. Ogden. So, McCulloch v. Maryland. This court case, it's a hot mess. Basically, it's the states. They're trying to push the federal government's power around. Okay, and long story short, a federal bank in Maryland was actually going to be taxed by the states. And McCulloch, he did not like this, and he did not like the federal government being pushed around, and he wanted to challenge this in court. And with this, uh, implied powers of the federal government are going to be established. And again, this whole argument is the federal government versus the states, and who is going to reign supreme. And we're going to see here that the feds are going to win, and this is going to expand federalism. So the states cannot push the federal government around. Again, there's an Ed Puzzle video that I want you guys to watch and check out for some more history. But this is going to expand federalism in our government, and also more power granted to the judicial branch. Next court case that I kind of lumped together with Marbury McCulloch is Gibbons v. Ogden. This is a very curious case when states are actually, they're wanting to, you have to have a license, steamboat license, in order to go through the Hudson River Valley area. And this is actually going to challenge the concept of interstate commerce, and basically didn't think it was right. Okay, and I will post an Ed Puzzle video on this. But the big deal with Gibbons v. Ogden is that the courts are going to rule on interstate commerce. And they're going to rule that the federal government has the supreme say between states. Okay, so a good example of this is interstate highways. Okay, we don't really necessarily think about rivers anymore, necessarily, as our main transportation, main way of getting around our nation. But we do think about highways. If it's an interstate highway, the states cannot establish a speed limit on those particular interstate highways. The federal government can. Now, if it's a state highway, the states can establish their own speed limits, if you will. That's why in Montana, there are actually some state highways that have no speed limits. Check it out. It's kind of crazy. And that's why you might see different states having, 75 miles an hour, 80 miles an hour, or even some lower speed limits too. But this court case is going to establish the court's authority to basically deal with issues between states. This is going to deal with issues between states, and how do you deal with these disagreements, and who is ultimately going to reign supreme? The federal government. So yes, this is going to be a ruling on interstate commerce, but ultimately it comes down to an expansion of federalism, and federalism being expanded, and the federal government's power being expanded, and who has final say. The supremacy clause, we've talked about that as well, and who is top dog, so to speak, in our government, and it's the federal government. Now, last thing here, I will do this every time I lecture over the court cases. The next lecture will be just a bit longer because I will be discussing two separate topics. But here's your summary of the court cases. So Marbury versus Madison established that the Supreme Court had the power of judicial review. This is the start of the Supreme Court, really. It is. Now, there were decisions and rulings made prior to this, but this is like the start. This is like the absolute beginning when you are studying court cases. And yes, I do agree with Mr. Beat. This is the most important court case in history. The McCulloch v. Maryland. So again, these two are going to be similar here, McCulloch and Gibbons. So issues between the states and the national government. And who is going to reign supreme? The national government is supreme. The national government, the supremacy clause, this is going to establish or reestablish the supremacy clause. Okay, so this is huge. And then the same thing with Gibbons v. Ogden. The supremacy clause. And this is going to establish federalism. And the central government becoming more and more powerful over the states and being able to tell the states what to do. Remember, the framers of the Constitution did not trust a strong central government, the Federalists versus the Anti-Federalists, and this is going to establish more of that control for the federal government. Also, with Gibbons v. Ogden, the interstate commerce, the issue of states between states is going to be defined as well. So that's it for today. A little preview for the next lecture for next week. We are going to study the biggest blunders in Supreme Court history. And we're going to look at some of the biggest and I'm not going to say stupid, but I will say some of the worst. That's probably a better word to use. Decisions that the Supreme Court has ever made. Now, we don't use good or bad in our class. We don't use those words. But there are some bad court decisions that are going to be made. And we will look at the worst decisions. And then we will also look at some court cases that are going to define or expand your civil liberties. And even as a student, there are some court cases that you as a student should know about and understand, and you have rights as a student in schools. Now, obviously, you're not in school right now, but you do have particular rights that the schools, they cannot take away from you as a student. And we'll discuss that as well. This is a shorter lecture today. I did that on purpose. And I just want you guys to understand that Marbury versus Madison is huge, 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 huge. Now, there are a lot of court cases out there. You could study court cases all day long. But we study the court cases that are the most important, that have left the biggest impacts on our federal government, state governments, on our nation. So just keep that in mind, that you can find a lot more court cases even in between 1803 and 1819. Okay, so just keep that in mind. It doesn't mean that after Marbury there was only one other court case after it. Okay, so there's a lot of other court cases out there. And we try our best to pick the most important ones that have left the biggest impacts on our country. Okay, so with that being said, that's our lecture for today. Hope you guys enjoy it. And please be safe. Please be safe, guys. Really, really do hope that you're making good decisions. Okay, and uh, thanks for watching.